Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On May 15th, 2025, Judge Stephen J. Hippler, concerned about information, sensitive information that had gotten out about the case that was, the court felt, covered by the non-dissemination or gag order in this proceeding, entered two orders, one to the state of Idaho, one to the defense, asking, amongst other matters, for the names of people both sides knew had access to information regarding this case within 7 days. If either side fails to comport with the mandates of this order, that they're doing so at the risk of contempt of court charges and other civil or criminal ramifications as may be appropriate. This information is due to be submitted to the court on or before May 22nd, 2025 via in-camera review. So this is nothing that the public is going to be able to see. But it appears that we have not yet heard the end of this. So at this point, we are awaiting for the other proverbial shoe to drop. What will this mean for this case? Will there be delays in the start of the trial? Will there be sanctions imposed on whichever side is deemed to have been the person who decided to violate this non-dissemination order and get information out to Dateline? Judge Hippler is extraordinarily serious. He addressed in open court on May 15th at the final pretrial conference the possibility of a special prosecutor who could be appointed here, who would have subpoena powers, who would have the ability to speak to witnesses, to potential culprits, to try to get to the bottom of who was responsible for this leak. Although this court order that went to the state and the court order that went to the defense does not apply to the media attempted to get the non-dissemination order vacated. They went so far as to going to the Idaho Supreme Court and failed. I'm referencing docket number 50482. This is in re petition for writ of mandamus or writ of prohibition. And you see there all of the members of the media coalition, represented, by the way, by Wendy Olson, Sol Reeves, her firm. She represents Dr. Schofield, the professor who is suing Ashley Gillard in federal court in a defamation matter. It's styled as Schofield versus Gillard. Ms. Gillard filed a document in early May in Idaho versus Kohberger seeking to get some information that was under seal. Judge Hippler struck whatever her filing was, so the public does not have notice of what Ms. Gillard was seeking, and told her, you need to go through the proper channels, which is to file a public records request. Returning to in re petition for writ of mandamus and writ of prohibition, this case was commonly known back in 2023 days when this matter was in Latah County as the Associated Press et al. The Associated Press was the lead media representative who was attempting to get the Supreme Court of Idaho to reach down into Latah County and vacate the non-dissemination order. But there were many other members of the press who joined in this action, one of whom, East Idaho News. If you do a quick search in any search engine of your choice, you're going to see that an interview of Keith Morrison was done by the Idaho News before this Dateline special aired. So you see there all of the representatives of the media, they were called the petitioners, versus the respondents were 2nd Judicial District of the state of Idaho, County of Latah, the Honorable Megan E. Marshall, Magistrate Judge. And then 2 other parties were allowed to intervene in this case, Mr. Kohberger and also the state of Idaho, Latah County Prosecutor. They were, in fact, the 2 sides that went to Judge Marshall. January 3rd, 2023, day 4 of this case, filed the stipulation for the non-dissemination order, convinced Judge Marshall to enter it. If you read the proceeding, you will see a synopsis, page number 2, of what the findings were. Basically, Media Coalition lost. They were found to have standing, meaning they had a stake in the action to come forward as the media, but they were told in no uncertain terms, the Idaho Supreme Court is a court of last, not first resort. You need to take your beef into Latah County before Judge Marshall. That's basically what this order found. You can go through, you can find out what a petition of writ of mandamus and in the alternative prohibition is, both of which were denied. And then you may be interested to learn that the respondents, 2nd Judicial District of the state of Idaho, County of Latah, and Judge Marshall were deemed to be the prevailing parties and were awarded cost, any cost that they incurred in defending this case. That information is located for you under the conclusion section, page 15. For the reasons expressed above, we dismiss the petition and deny petitioner's request for a writ of mandamus, or this was the alternative writ that they were asking for, prohibition. The respondents, as the prevailing parties, are awarded costs as a matter of course, pursuant to Idaho Appellate Rule 40A. So now we await to see, where will matters go here? Will there be sanctions imposed upon the party who is responsible for this leak? I would not be surprised if we see a adjournment of the case in chief, because the court said there, right there, first paragraph, it's going to take more time to try to seat an impartial jury in this case. All we can do as the public is stay tuned. If you have any comments, please leave them here. My name's Kathy. Thank you so much for joining us today.